Good afternoon, everybody. A little bit of a change. Our Friday afternoon webinars have now changed and we are trying something a little bit different. Today, of course, is not Friday, although I have to say by changing the webinar day, it has thrown me out because I do think it is Friday. I think I will be bitterly disappointed tomorrow morning when I wake up and it is actually Friday. So today's topic, quite a dry topic, but I'm going to help you work your way through employee, worker, self-employed or IR35, and I help you understand why it's important. I can see that we're still getting a couple of attendees who are still trying to log on, so I will give them a few moments just to get themselves back into it. Again, I think I have thrown everybody off their course because, of course, it's Thursday and not Friday. So just as an introduction, it's Angela Clay from HR for UK, and I'm going to be with me for the next hour as I go through our webinar. But of course, you know, if you need to go, by all means, I won't be offended, or of course, if you want the recording, that will also be coming out to you at the end of it. So I think we've got everybody on board who I was expecting, so I'm going to start and get cracking on today's webinar. So HR for UK, who are we? So HR for UK is a leading provider for HR and employment support. We have a payroll bureau, but we also do pensions and health and safety services. We have been providing the services to businesses for the last 30 years. In fact, it's more than 30 years. We've got over 30 years of industry experience, and we've got some fantastic 5-star reviews. But it's not about what I say about those reviews, it's about what our clients have to say. So I would strongly encourage you to go on to our website, which is www.hrforuk.com, to read some of those reviews and testimonials for yourself, to hear what others have got to say about our services. So of course you've got me, as I say, Angela Clay, as an HR and employment law solicitor. I am the Managing Director of HR for UK, and I'm responsible for HR for UK's role as a leading professional HR service provider for UK businesses. And I'm very proud to be the lead of HR for UK as we help you navigate through the various myriads of HR issues that come your way. But my vision, if you've been with me throughout the coronavirus crisis, my vision was to get you through that crisis. We are now starting to get there, but my vision still remains the same. It's to make sure that your business remains legally compliant by sharing knowledge and offering you clear, professional, practical advice and that all-important personal service and support. So let's have a quick look at what we're going to be covering today. As I said when I first started, it is quite a dry topic, but it is so important to make sure that you get it right. So today we're going to have a look at how to identify and determine the different types of employment status. I'm going to help you understand the rights and responsibilities associated to each category of employment status. We're going to have a look at the different factors that you will need to look at and consider when you are assessing each different employment status. We're going to look at the different legal rights and entitlements. And then we're also going to have a look at when IR35, which is the off-payroll rules, will apply. And I know that this is a term that many of you are thinking, what on earth is IR35? But I will come to that during the course of today. But of course, our webinars are only as helpful as you make them. So we would love to hear from you in relation to future topics. Otherwise, you might end up with a lot of boring, uninspiring topics, a bit like the one today. But please do ask questions. They don't have to be about employment status. It could be any employment matter that you may have. And of course, my webinars will not be the same without a little bit of a furlough update, which I have to confess are getting ever shorter every time I get to see you and deliver my webinar. For those of you who are new or haven't attended one of my webinars before, please use the box on the right-hand side to ask any questions that you have. I will answer those questions as we come to the end of the webinar. And of course, As I say, it doesn't have to be about today's webinar, it can be about anything, but as we do always, we will collate all of those questions, and at the end of it, together with the recording of this session, we will send you our Q&As. And this time, I'm also going to be giving you a downloadable handout where you will be able to check and compare when you are assessing that employment status. So I'm going to give you a download to be able to take that away. So I look forward to having a chat to you, answering those questions, and sharing as much information as I can with you about employment status. So it all started more recently in a recent Supreme Court case, and many of you might remember the Uber case back in sort of around about March time, where it found that the Uber drivers were considered to be workers. And why was this so important? Well, it was to establish some basic employment rights for those Uber drivers. And we now know that Uber drivers are entitled to, they've been classified as having a worker status, which means for them that they can have the national minimum wage, they have protection from discrimination, they have protection from unlawful deduction of wages. They are now also entitled to holiday and sick pay, regardless of what the contract itself says. So those are some of the fundamentals that workers are entitled to, and that was the leading case of the Uber case that determined that. The Court of Appeal had a similar case, which was the Addison Lee appeal that was going to be heard. And again, the basis of that hearing was again to determine employment status. But the Court of Appeal told the Addison Lee team that their case would not be allowed because there was no reasonable chance of success. It is really crucial for employers to understand the rights and responsibilities associated with each category of employment status, and it does become a little bit more complicated when an individual could be considered as employed in one instance, but in the other instance, they may be considered to be self-employed. And then, of course, we've got the complication of when does IR35, the off-payroll rules, apply. So let's get started. But before we start, I've already covered what we're going to be covering today. Those all important learning points. So let's have a quick look. Why is it so important to accurately identify the employment status? And the answer is quite simple, because an employer needs to know if an individual is an employee so that they can fulfill their obligations under employment law and tax. It's not only important under employment law, which of course governs the individual's statutory rights and benefits, but it has vast implications on making the correct tax and national insurance deductions and contributions. Basically, put quite simply, employees and workers are paid salaries or wages, and they get that payment after the deduction of tax and national insurance, and that is done through your pay-as-you-earn PAYE system. On the other hand, when you have someone who is self-employed, they are responsible for making payments directly to HMRC, and that is done through a self-assessment tax regime. And they have different deadlines that they have to submit their tax returns and, of course, make payment of any tax that is due. There are also different rules on national insurance contributions for those who are employed. Of course, those who are self-employed individuals have different contributions that need to be paid. Expenses are also treated differently for those who are considered as an employee or a worker in comparison to those who are self-employed. But for businesses, the key point is to, if you are going to be using someone who is what you deem to be self-employed, without really taking a moment to sit back and reflect and really look at what their employment status is, if you get it wrong, you could be storing up a large tax and national insurance problem for yourself, because it may turn out that taxman might come knocking on your door. So that's why it's really important to make sure that you get it right, because you want to reduce that liability that you may be facing for getting it wrong. And of course, that's not even talking about the employment rights, because again, you know, different categories have different employment rights. But what is employment status? I've been talking about employment status, but what does employment status actually mean? And again, it's quite simple. Employment status is a name that is given to determine an individual, whether an individual is self-employed or employed. And if they are employed, to determine whether they are an employee or a worker. Employment status is really just the individual's legal status at work, and that's all it is. So how do you identify and determine the different types of employment status? So this can be determined by the type of contract that you provide the individual, the way you pay them, who is responsible for paying tax, what are those individual rights and responsibilities, and your rights and responsibilities as an employer. And as I've already mentioned a couple of times already, so I'm going to bore you one more time, there are three main types of employment status, and that is going to be an employee, a worker, or self-employed. So let's have a look at those in turn. So an employee will be classified as an employee if you have a contract of employment. So that is a document from your employer which will inform you when your job has been offered and that individual has accepted the job that you have offered. You as an employer are going to provide regular work for that individual, and that individual needs to carry out that work personally. They must do that work, and of course you will pay them. An employee will have employment rights, and these employment rights include getting written terms, so a statement of written terms of employment. So these are also known as a contract of employment, a written statement of employment particulars, which is basically going to outline their job, their responsibilities. They're going to be provided with some basic information, which includes things such as pay, where they are going to work, sick pay, holiday pay, parental leave. It also now includes further information such as training that is going to be required in the job, and other benefits that they may get as an employee of the organisation. And this must of course be provided to them from day one of their employment. But it also allows an employee who has more than 2 years service, they will be entitled to a redundancy pay, and also the right not to be unfairly dismissed. And if you do unfairly dismiss them, they have the right to bring an unfair dismissal claim against the organisation. A worker, on the other hand, will be classified as a worker. Generally speaking, the employment relationship is a little bit more casual. And they will usually have a contract for services. So again, slightly different terminology. Rather than a contract of employment, they'll have a contract for services where they will do or provide a service for payment in return. This can be either verbal or it can be written. Of course, they will need to do the work personally, but there will be very little obligation on the employer to provide the work, and there will be very little obligation on the employee to do that work. And it's normally offered on, quite typically it's used under a 0 hours contract, but quite often this type of arrangement is used on an ad hoc basis. So the work is provided or offered and accepted if the individual wanted to do it on an ad hoc as and when basis. And of course, if the individual does agree to do that work, they need to then do it, and of course you need to then pay for it. So those individuals who are classified as a worker will have limited employment rights, but these rights will include written terms which will be outlining their job rights and responsibilities. They will be entitled to national minimum wage, holiday pay, and of course they will be entitled to pay slips. They will have the protection of unlawful discrimination. Again, they will also have protection for whistleblowing, and they will have protection for not being treated unfairly simply because they work part-time. So what is the difference between an employee and a worker? So employee status is an individual who has entered into or works or has worked under the terms of a contract of employment, and it can either be expressly written down, or it could be oral, or it could also be implied by the nature of the working relationship. To have employee status, of course, the individual must be obliged to do the work personally rather than sending a substitute, and I'm going to cover all of this in a little bit. And the employer is obliged to provide the work that needs to be done, and the employee is obliged to accept that work. The employer needs to have control over the way the employee carries out the work that they have been requested to do. Worker status, on the other hand, is sometimes a halfway mark between being an employee and being self-employed. Workers are entitled to fewer statutory rights than what employees do, but some key legal rights, again, are protection from discrimination, protection against unlawful deduction from wages, and the entitlement to national minimum wage, sick pay, holiday pay, and I've already covered those, so I'm not going to bore you with that again. But again, this will come out when I remind you when I send out that downloadable checklist for you. There are significant distinctions, so let's quickly run through what the distinctions are. So legal protections, some of the core legal protections that apply to employees only is that they are protected not to be unfairly dismissed, and they also receive statutory redundancy payment, of course, after they have had 2 years continuous service. A worker is not entitled to any statutory payments, so that is quite a key difference, and the protection that an employee gets, whereas a worker will not be entitled to that. Health and safety. So employers owe employees statutory health and safety protection, and this is not always extended to those who are self-employed contractors. They may not have that same health and safety protections that an employee will get. Although generally speaking, health and safety protection will be covered under the employer's occupier's liability insurance that you will have. Let's have a look at 2P transfer. So of course, 2P is the transfer of undertaking protection of employee rights. Only those employees will automatically be transferred to any purchaser of an employer's business under the 2P regulations. It does not apply to those who are self-employed. 2P regulations will only apply to employees. Tax is another a key area. An employer is responsible for deducting the tax and national insurance at source, so again through your PAYE system, from the salary that is paid to an employee. Whereas anyone who is self-employed, the individual themselves are responsible for paying their own tax and national insurance under their self-assessment. And I am going to caveat that because we do have those IR35 rules which may bite, and I'll come back to those shortly. I touched on insurance a few moments ago, but an employer must take out employer's liability insurance to cover the risk of employees injuring themselves at work. That insurance, that employer's liability insurance, is unlikely to cover someone who is self-employed or a contractor who is working on your workplace. Now, normally someone who is self-employed will have their own insurance to be able to cover them for any incidences that may occur. Liability, so again, when I talk about liability, an employer is liable for acts done by an employee in the course of their employment. So, for example, if an employee does something while they are acting on your behalf in the course of their employment, that might come back on you as your employer. Whereas a self-employed individual, a business does not attract that same sort of liability. Now, I've talked about self-employed people quite a bit in the last sort of 5 or 10 minutes. So let's just carve out a little bit on what self-employment looks like and what it means for someone who is going to have that self-employment employment status. So an individual will usually be classified as self-employed if they are responsible for when and how they are going to work. So they can dictate it themselves. They may be their own business owner, they might have their own company, or they might be working as a freelancer. You will have to, someone who is self-employed will usually invoice for pay rather than simply receiving a salary. And you will provide, you will issue a contract to provide services to your clients. As someone who is self-employed, you are able to send someone else in to the client to be able to do the work for you if it is appropriate to do that. You are also able to work for multiple clients, so you can work for different people, and of course you can charge different rates. So you might, for example, charge one rate working in one organisation and then charge another rate working in another organisation. But of course, someone who is self-employed does not get holiday pay and they do not get any sick leave. So if someone, is self-employed, they have very, very limited what I call employment rights, and these really only extend to protection on health and safety on a client's premises, and the protection against discrimination. So again, very, very limited sort of employment rights is given to someone who is self-employed. Now, sometimes you'll hear the words contractors or a freelancer. Now, those terms are normally used when someone is if someone is self-employed and they get work through an agency, for example, and they might be referred to as a contractor or a freelancer. In some situations, someone who is a contractor who has come through you through an agency, they may have worker employment status and rights while they are carrying out the contract for a duration. Because don't forget, somebody who's coming through you through an agency is usually for a defined period of time. You know, it might be to do specific project work. They might be covering, 3 months, 6 months, might be covering something specific, in which case during that period, they may well have worker entitlements. So again, you've got to make sure that if you are unsure, do check, because as I say, you don't want to be storing up a tax liability where it can be avoided. There may also be circumstances when employment status is not so clear-cut, and this is where you have to be really, really careful, because an individual may have worker or employee status depending on the work that they do, what their contract says, and the way they get paid. But don't look too heavily as to what the contract says, because it will be looked at more holistically when we are actually looking, I say we, when a tribunal is looking at that determination of employment status. But an individual, where it gets a little bit, I want to say muddy, where it's not so clear cut. Examples of that is when you've got an agency worker coming into your business to do some work for you. An apprentice, again, is not so clear cut. Whether you are, when you are a director of an organisation, it may not be so clear cut. Employee shareholders, fixed term or rolling contracts, again, it gets a little bit muddied and you need to look at it a little bit more carefully. Whether you are an office holder, where you are a piece worker or you work in the gig economy, you have someone working in your organisation on work experience, or as an intern, 0-hour contracts, or even a volunteer. All of those kind of working relationships can get a little bit confusing as to what that employment status is. And of course, we will always say to you, if you are unsure, it's always a good idea to check, have a look at it, but look at what determines that employment status. And I'm going to have a look at that in a little bit more detail in a moment. But of course, HR for UK are always here to be able to help and support you in making that assessment, to help you consider different working relationships that you might have within your organisation as to what it's going to what's going to determine their status. So let's have a look at those key factors when reviewing employment status. We already know that in recent cases, the key factors in determining employment status has been looking at the ability to substitute, so whether a personal service was or wasn't required. Have a looking at the neutrality of obligation, whether there is a lack of it, or whether there is an obligation to provide work when no obligation exists. And looking at the employee's obligation to perform or carry out that work and be paid for it. There are, of course, other factors that you do need to take into consideration. So, for example, you need to have a look at the control that is exercised by the organisation in the way that the work is done. So what does that control look like? Are there any financial risks? Does the relationship have the trappings of being a business, of somebody working on their own account, for their own account? The freedom to undertake other work, looking at equipment, who provides the equipment. A key factor to look at is the type of employee benefits and rights that there are, or the lack thereof. There are no employee benefits and rights. That kind of like gives the look and feel of someone who is self-employed, and they wouldn't have that worker status or that employee status. So again, those are things that we'd have a look at. But one of the big things that we would have a look at is what is the intention of the parties. Now, that may not be written down in a contract. Even if the intentions are written in a contract, a tribunal will always look further to look at what is actually happening. And these are just some of the issues that may affect the employment status. As I've said, contractual terms won't be the starting point in determining worker status. The tribunal will adopt a purposive approach, and then they will apply the legislation to the facts, because it is considered on an individual basis. It is not a case of one rule applies to all. It is considered on a case-by-case basis, and we've seen this time and time again as these cases crop up in the employment tribunals. So let's have a look at some of those factors in just a little bit more detail. So the ability to substitute. Now, this is one of the most important of the 6 factors when we are considering employment status, is whether or not there is a provision of a personal service. Is that personal service to be provided by you or the individual themselves? So for an example, if an individual is unable to carry out the role because perhaps they are off sick, for an employee or a worker, they have to do that work themselves, which means there is no ability to be able to provide a substitute. The personal service is required. On the other hand, someone who is self-employed, they may have the right to get someone else to carry out some or all of the work. And the reason why I say they may have the right, it will all depend on whether the organisation has a substitution clause. because there are some types of work where it is simple to get someone to come in and do the work for you. In other circumstances, you might require certain qualifications, or you might have certain clearance requirements. But it will again be looking at something specific as to what that substitution clause actually says. If you have a business where, for example, you have got a manager who is going to be carrying out the work for you, that is a real example of having a substitution, which means the personal service does not need to be carried out by the individual specifically, in which case they would not have that employee or worker status. Where there is no personal service required, that is a clear indication of someone who is self-employed. So when considering substitution, I think I've already covered this, but let's have a look at, has the substitution actually occurred? Have you actually put someone else in there to do the work that you were going to do, or the individual was going to do? And if there has been an actual substitution, how does it work from a practical point of view? This could be useful for contractors who are in similar roles in different organisations. So again, having a look at that substitution clause is quite important, and having a look at how freelancers and contractors, other freelancers and other contractors that are used in the organisation, what does their substitution clause look like, and how does that actually look like within their organisation? And is there a right of substitution included in the contract? Again, don't get too hung up on the wording of what the contract says, because again, a tribunal will look at what actually happens. Is the right of substitution done through a personal service company? Is it through the agency or the hirer? So again, you will need to have a look at what those substitution clauses look like, if there is one. As a business, you will need to have a look at whether you have your own substitution policy. So if you are going to be using subcontractors or individuals who are self-employed, you know, are there going to be restrictions that you will need to impose? For example, are there qualifications? Is there specific training that you will require them to do? Are there security clearances that need to be cleared before you can have someone coming in? It's a bit like having a plumber coming to you to do your work. You know, you've engaged someone to be a plumber. They can't do the work, and instead they send an electrician in. Clearly, in most instances, I don't think an electrician will be able to do plumbing, but you never know, they may be able to do. But that would be a typical example of where there will be restrictions on, you know, sending in someone with those specific qualifications. Mutuality of obligation. So this is an obligation on an employer to provide work, and the obligation on the employee to accept that work. For contracts of employment to exist, the employer is obliged to pay the employee for the work that they do, and the employee themselves are obliged to carry out that work. For an independent freelancer or a contractor, it is not the same. There is no obligation for them to actually do that. So again, for a freelancer or a contractor, or someone who is self-employed, there will be a clear schedule of work that needs to be provided in the agreement of what work is going to be carried out. And someone who is self-employed should not be removed or be expected to carry out tasks that fall outside of that scope of that schedule of work. And likewise, they should not be expected to go and do work that falls outside of that scope. So it's very, very specific on what someone who is self-employed can do, and again, what an employer can require an employee or a worker to do. So let's have a look at control, the direction and supervision of this scenario. I think with an employee, it's quite straightforward. Who has the control? Of course, it's the organisation that has the control. It's the organisation that has the direction of where their business is going to go. And of course, they will implement measures to be able to supervise the work that's going to be carried out. So it's much easier to define for an employee scenario. But if you're operating as a self-employed, there are various things that we can have a look at, looking at that control, looking at the direction, and looking at that supervision. So let's have a look at the control. Is how is the work carried out? So for someone who is self-employed, schedules of work should specify what needs to be done rather than how it needs to be done. You are an expert. If you are self-employed, you're an expert in what you are doing. You don't need your organisation where you are going to tell you how to do it. If the organisation is telling you how to do it, it does not fall under the self-employed category. What is acceptable? So the organisation can impose reasonable guidelines, such as health and safety, but they shouldn't be telling you how the job needs to be done. And certainly, you would not have someone sitting on your shoulder as someone who is self-employed, looking over to see what you're doing. As a contractor, as someone who is self-employed, you will be able to get on and do the job without supervision. If supervision is required, that sort of gives an indication that it is more of an employee-worker relationship rather than someone who is self-employed. Of course, don't get confused. Checking on the progress of a project or its deliverables is not the same as supervision. So, you know, checking on how you're getting on certainly isn't supervision. That is, you know, merely just checking on how a project is going to be, you know, how you are getting on a project. Training and appraisals are for employees rather than contractors. And the use of language is important here because a project meeting shouldn't be described as a worker appraisal. You know, there are certain prescriptive requirements of training that needs to be done. There are certain organisations where there are specific training requirements, but that allows you or supports you to be able to carry out the job that you are doing. And that doesn't necessarily automatically mean that that gives you employee status. There are certain types of businesses where you do need to go through so the example I'm going to use is like for McDonald's. McDonald's has certain standards. They have certain procedures that need to be followed. Those standards and procedures are part of the franchise agreement. They're part of a much bigger agreement. That training is different to training an individual on how to do the job. So again, you know, just be mindful on terminology. Just because terminology is in an agreement doesn't necessarily it means one thing or another. So again, it's looking at it holistically as to what impact that is going to have on employment status. A staff handbook is for employees only. If, however, there are procedures that a contractor needs to follow or someone who is self-employed, those are procedural statements that need to be followed. They are not employee handbook or employee guidelines. So again, making sure that that terminology is clear in anything that you may share with individuals coming into your organisation. The more of an expert an individual is, the less likely they are to be under the control of the organisation that they are going into. So again, the more of an expert, you are more likely to be considered as self-employed rather than being employed. But, you know, anyone who is self-employed, you know, shouldn't be undermining the expertise. Sorry, an employer, an organisation should not be undermining the expertise of someone who is a contractor. And of course, don't undermine those contractual rights of control, supervision, or direction, because more often than not, practicalities of it, the actual looking at what happens in real life, can be quite different to what is in an agreement. So having a look at where and when work can be carried out. So if there is flexibility as to when and where the services can be performed, this should be recognised in a contract, or guidance should be issued. Now, this is a little bit of a funny one, because of course pre-COVID it was pretty I want to say pretty clear cut. You were either in an organisation or you're working from home, or you had more flexibility. But of course, what we have learned from having COVID is there is actually a lot more flexibility on where and when people can work. But that should not have too much of an indication as to whether someone is self-employed or a worker or an employee, because of course you would have a look at it holistically. But if someone is a contractor or self-employed, they may be able to do the work somewhere else. So again, having a look at where and when the work is going to be required to be done. If it can be moved from one site to another without having the ability to determine the order in which that's going to be carried out, or those tasks are going to be carried out. If there is structure to it dictated by someone else, that may give an indication of an employment status as an employee or as a worker, rather than being able to dictate your own priorities and tasks. That would give more of an indication of someone who is self-employed. Where a role is based on targets or deliverables, this is far less consistent with employment law or employment status than working on an hourly rate. So again, don't be fooled by targets. We all have targets. Targets when you've got teams that need to, sell X amount of vehicles, or sell, X amount of widgets, for example, is different to targets of having to reach a certain milestone in being able to provide those deliverables. So again, having a look at what is actually being asked of you, and have a look at what the terminology is. That will guide you whether it is an employee, worker, or self-employed. Financial risks. Financial risks for an employee is very little. In fact, when we talk about financial risks, it's always looking at it as the from a self-employed point of view, because someone who is self-employed, the financial risk is so much greater, and that will be a really good indicator of self-employment status. There are some factors that we can have a look at, which is when we are considering that financial risk. So having a look at the provision of equipment. Who is responsible for paying for that actual equipment? Somebody might provide you with a certain piece of kit. That does not necessarily mean that they, the financial risk isn't with you, because the financial risk is with you because you still need to purchase that equipment. Contractual indemnities. So, for example, the obligation to correct defective work in your own time and in your own cost. That is a financial risk. An employee will have less of that financial risk. I mean, there might be a liability for losses in your contract, but for someone who is self-employed, that is much greater than someone who is an employee. Short or no notice period to terminate the project. That is a huge financial risk on a contractor or someone who is self-employed. The requirement to have different forms of insurance held by the individual or through the personal service company. Payment terms as someone who is self-employed is normally much longer than someone who is an employee. An employee gets paid regular as clockwork. They might get paid weekly, they might get paid monthly, whereas someone who is a contractor or self-employed, their payment terms may be much, much longer. So again, that financial risk to them is a lot greater. There are, of course, upsides and downsides. Financial upsides, if there is early completion of a project, great. Downside, of course, is if completion is late or delayed, that may have an impact on your financial risk. A big one when you're having a look at self-employed status is a business on your own account. So if you have a business that is yours, you are responsible for it. This is very easily identifiable and separate from employees. You know, when you are running your own business, you can dictate a lot of things as your own. You know, you can decide how to present things to your customers or clients. You look at your services, you look at your products, you perhaps look at retail. You may have a combination of a service that you're going to provide which may separate from you know, delivering, for example, post offices. You know, you might have a retail side to that. You might be selling cards, you might be selling confectionery, you may have a whole range of different things that you are selling, which is separate to the post office services that you are going to be providing to customers coming in. That is something that you can dictate. That would be seen to be having a business of your own account. Quite often, more often than not, you'll be acting in a partnership, or you will be registered as company's house. You would be having different ID badges to someone who is working in an organisation. You don't receive standard staff benefits. So again, if you've got your own business, you are not going to have benefits that employees would get and employees would benefit by. If you have a website, again, the domain name and the email addresses will be different if you are a self-employed individual to that as an employee. Because an employee will, of course, have the company's employee address, whereas if you've got your own business, it will be that of the company, which will be separate. Of course, having, you know, if you have a company of your own, you will not be part of an organisation's meetings. You won't be part of strategic meetings. You won't be part of team meetings. You will only be responsible for meetings within your own business. And of course, you will not be subject to or responsible for the delivery of any formal performance appraisals, because of course it's not you are not part of that organisation. So again, having that individual look and feel of a business will definitely separate you out from having that employee or worker employment status. And of course, if you are excluded from a bigger organizational chart, because of course you have your own business, that again really identifies that you are self-employed. You are not likely to be classified as having worker status or as employee status. Exclusivity is another key thing that we often look at, is providing services to more than one a client or customer is really evidence of being self-employed. Most organisations who have employees will normally have a requirement that the employee works exclusively for that employer. Of course, we can't have exclusivity clauses in 0-hour contracts, because of course we know that is banned, but exclusivity is another clear indicator of you know, employment status. Being able to provide work for more than one client or customer, it is a clear indicator of being self-employed. So I've talked very briefly in some cases about IR35. So what is IR35? And IR35 is just another name for the off-payroll working rules, and it's designed to assess whether a contractor is a genuine contractor or whether they are a disguised employee, and it is all for the purposes of paying tax. So when do IR35 rules apply? So we know for the public sector, this has been around since April 2017, but there was a big shift change where in April 2020, where that was extended to the private sector. But it only applies to the private sector for medium to large companies with turnover greater than 10.2 million and a balance sheet of greater than 5.1 million, and they have an average number of employees that is greater than 50. So for most SMEs, it will not apply. But it is really essential to make sure that you do assess subcontractors, have an audit trail, so that if HMRC does come knocking, you can provide the evidence that they will need to show that you are applying the rules correctly. And when we're looking at IR35 rules, they may apply if a worker provides their services through an intermediary. Now, an intermediary is typically a worker's own personal service company, but it can also be a partnership, it can be a managed service company, or it can also be an individual. Now, the IR35 rules determine that workers who would be normally classed as an employee, if they were to be providing their services directly to a client, are treated for tax and national insurance as the same way as an employee. So a prime example of that is I have a board of directors. One of those directors, of course, is our chairman. He works for HR for UK 1 day a week. Sorry, not 1 day a week, 1 day a month. And because the work that he carries out for that 1 day a month, he is considered that the IR35 rules will apply to him, in which case I have to process that 1 day a month through our PAYE system so that we can deduct the tax and national insurance and pay that over to HMRC. So the IR35 rules apply tax and national insurance contributions, and of course that must be deducted and paid over to HMRC. I've got 10 minutes left. For those of you who are still with me, well done. As I said right early on, it's quite a dry topic. I've got loads of questions that have come in. I am going to come to those, but quickly before I get to that, let's just have a quick wrap up on the furlough update. As I said, the update is getting much smaller because, of course, we are winding down the scheme. We are starting to get to the end of that. So just very quickly, whistle-stop tour on the furlough update. We all know that the coronavirus job retention scheme has been extended until the 30th of September, when it will finally come to an end and be wound down. So claims for furlough days in May must be made by the 14th of June. So please do bear that in mind, that date, 14th of June. You must submit your claims for your May furlough days. Don't forget that for periods starting on or after the 1st of May 2021, you can claim for employees who were employed on the 2nd of March 2021, as long as you have submitted a PAYE real-time information submission to HMRC at some point between the 20th of March 2020 and the 2nd of March 2021. Of course, we know that you do not need to have previously claimed for an employee before the 2nd of March 2021 to be able to claim for periods starting on or after the 1st of May. We know that for periods on or before the 30th of June, you can claim up to 80% of an employee's usual wages for hours that are not worked, up to a maximum cap of 2,500. But of course, we know that we've got that step change that is coming in from the 1st of July 2021. The level of the grant will be reduced for each month, and employers will now, from that date, be asked to contribute towards the cost of furloughed employees' wages. And again, you do not have to have previously claimed yourself or claim for an employee before October 2020 to be able to make that claim. And again, employers can claim furlough employees for any amount of time and any work pattern while they have been while you're able to make a claim for that grant. But of course, it's for those hours that are not worked. The hours that are worked are paid at their normal wages, a rate of wages. And of course, employers will always need to pay the employer national insurance contributions and the pension costs. But the last thing on furlough is, do remember that you can no longer make claims for periods ending on or before the 31st of October 2020. So let's have a look at those questions. As I say, we've had some brilliant questions coming in. So let's have a look. Callum, thank you for some of your questions. So a question here you have is, does a worker have a value in their worker status? In other words, can they sell their contract to someone else? The answer to that is no. If you have worker status, it is looking at what that relationship is with the organisation that you are providing that work to. You cannot sell it over to someone else. You can't say to someone else, "Can you come in and do it for me, and I will pay you for doing it," or the organisation that I was supposed to work for is going to pay. You cannot substitute. So I think the simple answer to that is no, you cannot sell your contract to someone else if you have worker status. I hope that answers your question. But again, don't forget, I do take all of these questions and I do provide a more comprehensive answer that goes out in the Q&A, which will follow with this recording next week. So the next question I have, if you have a contract with an organisation which enables you to employ someone else to carry out the work, this would make you self-employed even if you actually do the work yourself. Absolutely. So this is an example of you subscribe to another organisation which enables you to employ someone else. So this type of scenario we have it as I've got my business, because it would be your business that you have. An organisation is enabling you to provide a service to perhaps customers or clients, and I have a manager who's going to come in and manage that that business for you. That would be self-employed. Even if you can get a manager in, if I'm doing the work myself and I have an organisation, it's my own business, even though I'm enabled to do it, even if I'm doing the work myself, it will be self-employed. It is a self-employed relationship. It will not automatically give you that worker status or that employee status. But again, it will be considered on an individual basis, case-by-case basis, and to be, in most cases, it would be rare to find that it would be that an organisation is enabling you to do something, you do the work yourself, where it would be where you would get that worker status. But again, it will depend on case-by-case basis. I hope that answers your question, and I'm just going to check to make sure that question doesn't carry on. No, it doesn't. Great question. And again, you know, it's having a look at everything, not just one thing in isolation. It's looking at a number of those factors, and even the factors I've talked through today, there are other factors as well which will need to be taken into consideration. I've only identified the big ones that tribunals normally look at when they are establishing employment status. Another question, great question coming in here. A GP is classified as self-employed, yet they will be required to use equipment systems under the approval of the health board. They will be provided with training, etc., on how to use this equipment and how to follow the rules and procedures and guidelines by the health board. Doesn't that make them more of a worker? So, brilliant question. That is really, really a good question. So again, in that particular scenario, I would say that they would not have worker status. And the reason why I would say that they do not have worker status, whilst they are provided with the equipment, you would probably have a look at in a GP practice, who paid for that equipment for them to be able to use it. You will more than likely find that the GP practice would be a business in their own right, and that business would have purchased that equipment. It may be equipment from the health board, but looking at the financial risk, the company itself would have purchased that equipment. Having the procedures on how to use that equipment is not a handbook. It's not an employee handbook. It is a guide on how to use that piece of kit. It's how to switch it on, how to get it to do different things. So for example, I'm going to use a heart monitor as an example. It's how to switch it on, how to record that heartbeat, and what to do with that information afterwards. That is a practical guide. It is a how-to guide. It is not an employee. It's not to be confused with what is an employee handbook on how things are going to be dealt with. So again, you know, just because a board that governs the type of organization you have is going to provide you with certain things, that does not automatically mean that your organization is then going to give you, as the individual who's carrying out that work, worker status or employee status. I would very much argue that that still would remain as self-employed status or as a contractor status. So I hope that answers your question. Brilliant question, because again, you know, some people think, well, you've given me all of this, I'm automatically considered an employee or a worker. It is not necessarily the case. So it's again looking at it on an individual case-by-case basis. I have another question here. Sub-postmasters, self-employed or workers? So I am going to put my head on a block here, and I am going to call this one. I would be saying, and for all you postmasters who are on the call today, I'm sure there are many of you, postmasters are self-employed. I do not believe that you would be classified as a worker. I would be very surprised that if you were given worker status, because there are so many factors that are taken into consideration when determining worker status in the relationship. I think with postmasters, the relationship is very different. It is distinct from what has come out of the Uber case. It's very distinct on what has come out of even cases previous to that. Pimlico Plumbers, the Addison Lee, it is quite different and quite distinct. I know the jury will soon be out on that one, but I do not believe that you would be given worker status, and I do believe that you will be self-employed simply because you have your own business. You've got your own organisation to be able to operate and provide that service. You know, yes, you have got the Horizon system, which you need to use to be able to report into Post Office Limited. You know, the takings, the services that you are providing, but that in itself, you know, have a look at, you know, you would have had to pay for I presume, the Horizon system as part of, you know, having that agreement with Post Office Limited to be able to deliver that. Post Office Limited will give you manuals on how to do things, but it is not going to sway it so that is considered to provide you with employment or employee status or worker status. I do have a couple of other questions that have come in. So again, these are great questions, and I will circulate these at the end of the recording. So another question that came in beforehand, is someone who has worker status entitled to statutory sick pay? So if an individual does have that worker status, if they qualify, yes, they will be able to claim, be paid statutory sick pay. And when I talk about qualification, it means that they are unfit to work for 4 continuous days, and they are earn above the lower earnings threshold. Another great question, do I need to issue a contract for a self-employed person? Yes, it is always best practice to document the working relationship, but what you would give someone who is self-employed is you would give them a consultancy agreement or a self-employment agreement. You would not be giving them a contract of employment or a contract for services, because of course a contract for services is for workers. A contract of employment, of course, is for employees, but a consultancy agreement or a contractor's agreement will apply to those who are self-employed. I've got a couple of other questions that have popped into the question box. So let's get this one up. Again, I think this is quite a topical question. Post Office provides Horizon. Postmasters do not pay for it. Okay, so that is the piece of kit that they provide. I still believe that postmasters will still be classified as self-employed and not have worker status, even if the Horizon system is part and parcel of them being able to do their job. Because of course, don't forget that without the Horizon system, they will not be able to service the customers that are coming into the post office itself. But again, that is only one tiny factor that will be considered in a much wider, much broader assessment of what that employment status looks like. So again, I can't stress enough, it is not one individual thing that is looked at. It is a variety of things, and looking at it holistically and also on a practical point of view. What actually happens? What is the actual intention of the relationship that's going to determine that that employment status? Don't get bogged down on one or two things out of it. It is a number of things that are taken into consideration when a tribunal looks at that worker status. So I am going to turn into a pumpkin. I have lived up to my reputation when carrying out these webinars. I have long passed my sell-by date or my best before. Thank you to everybody who has stayed on. I hope you have learned a lot from my session today. Employment status is, as I say, quite a dry topic, but it is so important for businesses to make sure that they get it right for so many different reasons. Of course, as always, if there are any questions, if anybody is unsure, do get in contact with us today. That is what we are here for. HR for UK are your providers to be able to help you. For those sub-postmasters who are on the call today, who are listening to this webinar, you get the opportunity, it's a free service, to give us a call. Let us help you. Let us help you assess what this means for you. Just a quick reminder where you can get in contact with us. You can go to our website, which is www.hrforuk.com. You can give us a call, which is 01455 444 222, or you can drop us an email, which is info@hrforuk.com. But of course, don't forget, we can provide you with lots of help and support, not just in relation to HR. We can help and support you with your payroll needs. We can help and support you with your training. And of course, we've got the Kickstart scheme where you can get a kickstart into your organization, which is going to help and support you. Very quickly, our next webinar, we're going to try again on a Thursday afternoon. Let's see how we go with that. Our next webinar is on Thursday, the 24th of June. We are going to be talking about long COVID. Whilst most of individuals who have had COVID as an illness, some of those symptoms pass quite quickly, but some others have been left with long-lasting symptoms, some lasting weeks, some lasting months. So we're going to have a look at to see how long COVID is going to have the impact in businesses, and of course how to manage that. And we are going to be getting Anna Harrington from WHRB Limited, who is an occupational health specialist, who is going to co-host our long COVID with me on the 24th of June. So do put that date in your diary. Of course, we have our HR surgery. This is a fireside Q&A session. There is no topic really to be discussed. So come in with any question, doesn't matter what type of question it is. Our HR surgery is there to, as I say, answer those quick fireside questions. And that is going to be held on Wednesday, the 9th of June at 11 o'clock. So look out for those invites. And Vanessa Monroy is going to be leading on our next HR surgery. HR for UK are here to help. No question is too hard or too difficult for us. Do get in contact with us. I've given you those contact details. We are always here to help you. Thank you for your time today. It's been a pleasure talking to you, sharing that knowledge. And of course, if you've got any individual questions, do get in contact. We'll be more than happy to help. That's it from me. Thank you and enjoy the rest of your day. Take care and bye for now.